All right, we can go ahead and call Mr. Smith's matter if the parties want. That is 25T435. Mr. Smith appears before the court pro se, meaning without an attorney. The last time that we were present, Mr. Smith had sought to relieve court-appointed counsel of her services and did not request new court-appointed counsel, thereby electing to proceed pro se. Mr. Smith, how would you like to proceed in your case?
I filed a motion just this morning. I'm not sure if
It hasn't been filed with the court yet, meaning they haven't uploaded it yet.
Yeah, I hand delivered it just this morning.
All right, so we're looking to schedule a motions hearing?
Yes.
And what type of motion to put the people on notice?
Dismissal.
On what grounds?
Violation of constitutional rights.
All right, so a constitutional-based motion. Are you alleging a violation of a particular section? Or are you alleging that the statute itself is unconstitutional?
It's predominantly the Fifth Amendment, 14th Amendment, in regards to legal counsel and due process.
In regards to legal counsel, you fired your attorney at your last appearance. You haven't sought appointment of a new attorney. In what way have your rights been violated there?
Well, on September 30th, when I was summoned to court on the court's docket to courtroom 103, I went over the building and was unable to find it until I finally intrigued with the guards who pointed me in the direction of the clerk's office. With that being on the docket as a courtroom, and the possible consequences of failure to appear that comes with more fees, fines, and possible jail time. I'm not sure why that's in the clerk's office where I was isolated behind closed doors without that legal counsel, which was before.
So in that instance, you're referring to a different case, not this case, 25R549. So nothing in relation to that case is going to be referenced in this case. To the extent that you're alleging other violations, though, we'll set your motion for a hearing. Keep in mind that motions deemed to be groundless, frivolous, vexatious, or otherwise contrary to law will not be heard. But I don't have a copy of the motion at this point, so I can't make that determination. We'll set it for a hearing on motions to the extent that any of it relates to this case, not some other case. And let's get a date.
Your Honor, I do have paperwork that does say that that is for the 2025R000549.
Right, that's a separate case. This is 25T435.
Okay.
Infraction cases operate under a separate set of rules, and those do get heard for first appearance at the court clerk's office. The case that you're before the court on in this courtroom right now is that 25T435.
Hey everyone, welcome back to today's video. In this episode, we take a closer look at two individuals appearing in court, including one person whose case continues from an earlier discussion. In the previous situation, he chose to dismiss his attorney after she did not agree with his argument related to the right to travel. Confident in his own approach, he decided to represent himself moving forward. As the hearing begins, we get a clearer view of how that decision affects the process and how events unfold in the courtroom. Let's follow the situation step by step and see how it develops.
So the charges that you have in this particular case are higher level allegations than what you would have been initially for a first appearance authorized to appear in room 103 for 103 for the basis of, not the number 4. So again, we won't be hearing any contentions in relation to anything about the infraction case. I'll let you know as well that people are not entitled to have court-appointed counsel in infraction cases. But again, that's separate and apart from you're entitled to have hired attorneys, but the legislature does not authorize public defender or court-appointed counsel or similar to appear on those. And in addition, the district attorney's office doesn't appear on those cases either. All right, for a hearing on motions in this case, I can set a motions hearing on April 1st at 1:30. Can the parties accept that?
That was April 1st.
April 1st,
Yes, ma'am.
1:30.
Yes, ma'am. That is fine. At 1:30.
Correct. As it relates to this case, Mr. Smith, again, 25T435, we had some of this conversation last week. I just want to make sure to clarify on the record when the people are present that you are electing to proceed to a motions hearing and moving forward in this case by representing yourself. Is that correct?
I'm still in the midst of studying and trying to understand my own rights. So it's a challenge. It definitely is. I'm not going to lie about that. So the representing myself is still, I'm pending it in my stance of everything. Just because I'm in a financial hardship, so finding a free attorney to take the place of a public defender it's almost impossible.
Mr. Smith, I want to reiterate that the last time that we were here, you elected to essentially fire court-appointed counsel and proceed by representing yourself. Is that correct?
That was because I was under the impression that she was unable to defend me.
Unable to ethically file the motion that you sought her to file. Is that correct? According to her.
According to her, yeah, I'm sure.
And you did not seek an alternative defense counsel to be appointed to you. You elected to proceed without the benefit of an attorney at that time. That doesn't mean that you waive your right forever if you can find an attorney, but you were not requesting alternative defense counsel to be appointed to represent you, correct?
No, Your Honor, not from the courts.
And is anybody forcing you to decide to, at this point, represent yourself?
I feel more pressured into it, yes, Your Honor,
In what way?
because I don't have the defense of a public defender.
You had one, you fired her. So in what way are you being forced to do this?
I didn't necessarily fire her, Your Honor. When she refused to even hear me out when I mentioned a few words, that's not, in my understanding, it's not firing her.
We
I
had
was
a
pretty
pretty
shut down.
lengthy hearing on the last court appearance, Mr. Smith. Do you recall that hearing on the 9th of January?
Yes, Your Honor.
At that time, you no longer wish to have the services of the public defender, is that correct?
Yes, Your Honor.
And you did not seek appointment of alternative defense counsel, is that correct?
Not from the courts, Your Honor.
So that's correct, yes?
Yes, Your Honor.
And did anybody force you to do that?
No, Your Honor, I still feel pressured into it, though.
In what way do you feel pressured?
Your Honor, I was under the understanding that I have the right to an attorney, and if I cannot afford one, then one will be provided for me.
One was provided for you, correct?
Provided for me in the stance that she would not defend me.
And you did not request alternative defense counsel to be appointed to represent you, correct?
Not from the courts, no.
So nobody forced you to make that decision, is that correct?
Yes, Your Honor.
Was that your own choice?
Under coercion, yes, Your Honor.
Who coerced you?
The pressure from representing myself in this. I was under the impression that's what you guys were telling me, was since the public defender would not defend me, my only option was to seek my attorney on my own cost and time and effort, or represent myself.
When someone chooses to represent themselves in court, it is essential that they clearly understand the details of the case they are appearing for. Being aware of the specific matter being heard is a basic but important step in presenting any form of argument or defense. Without that clarity, the situation can quickly become confusing and difficult to manage. It is also noticeable that individuals who rely on unconventional legal ideas are sometimes involved in multiple cases at the same time, which can add further complexity and make it even harder to handle the process in an effective and organized way.
Did you ask for court-appointed counsel, alternative defense counsel?
No, Your Honor.
Are you asking for that now?
No, Your Honor.
Is anybody forcing you to make that decision?
No, Your Honor.
Is it your own voluntary choice?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, intoxicants, or prescriptions that affect that decision?
No, Your Honor.
Do you understand that you're going to be held to the same legal standard as a licensed attorney?
I'm still under study and research and education of myself.
Do you understand that you're going to be held to the same standard as a licensed attorney?
To an extent, yes.
I'm telling you, you're going to be held to the same standard as a licensed attorney. Do you understand that?
Yes, Your Honor. Do I need a
I'm not asking if you understand all of the things that licensed attorneys have had to go through in order to be licensed. I'm asking you whether or not you understand that the standard that you will be held to is that of an attorney.
I understand that part, Your Honor. I just don't understand the standards that they are functioning and operating by.
And nonetheless, you're not asking for alternative defense counsel to represent you. Is that correct?
Not from the courts, Your Honor. I have trust issues now.
All right. So you are not seeking to have an attorney represent you, someone who has been trained in this field and is licensed to practice law in the state of Colorado. Correct?
On my own accord and effort and time, I am seeking. So,
And you retain that right always, but you're not asking the court to appoint someone else
no, Your
for
Honor.
you. Is that correct?
Yes, Your Honor.
And do you understand that the top charge against you is failure to display proof of insurance, which is a class 1 traffic offense? You could be sentenced to up to 1 year in the county jail if convicted, or you could receive a fine of up to $1,000 or both. And that one is a 4-point offense. Do you understand that?
Yes, Your Honor.
And nonetheless, you're seeking to move forward, at least at this point, without an attorney to represent you.
At this point, yes, Your Honor. I'm still seeking on my own accord.
But you have filed a motion and you're asking the court to set a motions hearing and you don't have an attorney. So I want to make sure that you are validly waiving your right to counsel before I set this hearing.
I'm under the impression that you're telling me that I still have the right to seek an attorney on my own.
You do, but by filing this motion and asking for the hearing to be set when you don't have an attorney, then we need to talk about the waiver. It's not binding. You can change your mind. You can hire an attorney. However, at this point, asking to move forward without the benefit of an attorney and asking you to set court time aside for a motions hearing does require a waiver of counsel if that is how you want to proceed.
I was not under that understanding at all. No one's here to advocate me as far as legal representation to.
So what would you like to do, Mr. Smith?
I'd like to move forward with the motion.
You want to move forward with the motion?
Yes, Your Honor.
Despite not having counsel?
Yes, Your Honor.
And again, just to confirm, is anybody forcing you to do that?
No, Your Honor.
And you understand the rights that you have. You were appointed an attorney, you relieved that attorney of her services, and you did not request new court-appointed counsel, correct?
To an extent, yes.
To what extent? It's a yes.
To my understanding that the public defender denied me. I didn't deny her.
What was explained to you was quite clear and straightforward. The court indicated that your proposed defense was not recognized within established legal standards, and your public defender was not obligated to present arguments that fall outside accepted legal practice. You were then given two options: either hire a private lawyer at your own expense or continue by representing yourself. As you stated that you did not have the financial resources to retain private counsel, you chose to proceed on your own. However, this choice can present serious difficulties, particularly when there is limited understanding of court procedures and what is expected during the process.
She is no longer representing you, and you have not requested new
I do
counsel
understand
from
that,
the
Your Honor.
court, correct?
I do understand that, but I was not the one to initiate the denial.
And you did not request new counsel, which you
Correct.
could have, correct?
I'm seeking on my own accord, Your Honor.
All right. I do find a knowing, voluntary, and intelligent waiver of counsel. Certainly, Mr. Smith understands the rights that he has to be represented by an attorney. He was appointed an attorney. He did not ask for a new attorney when the services of the public defender were terminated. You retain the right to hire an attorney at your own expense and on your own behalf if you wish, or seek alternative defense counsel. You are not doing so. So at this point, I do find that knowing, voluntary, and intelligent waiver of counsel. We'll schedule a motions hearing on your motion on April 1st at 1:30. Keep in mind that the court cannot accept a letter from someone who is not here to testify or something similar. So if you're seeking to utilize the subpoena power of the state to obtain the appearance at trial of a witness who you may wish to have testify on your behalf, then you can go down to the court clerk's office and have subpoenas issued. And I believe that we already discussed how to get discovery. Is that correct?
Yes, Your Honor. I was provided that.
All right. So I'll note Mr. Smith believes that he has been provided discovery. I would encourage you, you're not required to speak with the district attorney about the facts of the case, but if you periodically want to inquire of their office whether or not any additional discovery has been provided in your case to make sure that there's that free flow of information, I would encourage you to do so. Anything further for Mr. Smith at this time?
Not from the people, Judge.
And Mr. Smith, is there anything further at this time?
No, Your Honor.
All right, so we're going to set that motions hearing as I've stated, and I'll encourage you to be prepared to proceed to the motions hearing. Anything further?
No, Your Honor.
Anything further, Mr.
No,
Smith?
Your Honor.
All right, and I just want to remind you that any allegations brought up in the motion that you filed in 25T 435 that relate to the infraction case, which was that 25R 549, any of those issues will not be heard. Any rights that you may have from that case are separate and apart from anything in relation to this case. All right, we'll see you on April 1st.
Thank you, Your Honor.
That interpretation is not entirely accurate. What was actually explained is that the public defender was not comfortable presenting a right to travel argument because it does not align with established legal standards. As a result, she indicated that she might need to step aside, allowing you the option to find another attorney who would be willing to pursue that approach if you chose to continue with it. This situation did not arise from any failure on her part, but rather from a difference in legal strategy and understanding. Continuing with a position that is not generally recognized in court can make it much more difficult to build a clear and effective defense.
Indiana versus Bo Matlin.
Yes, sir.
2602 CM 250. It is separate initial hearing. This is a recall, Your Honor.
Sorry about that. No, exactly. It's about your rights. I know my rights. I don't need an attorney. Thank you.
Right, Ms. Matlin, you are here today for an initial hearing. Tender to the court is, has been filed, notice living man, declaration of status. Those are signed by you and have been entered. There's also an affidavit of truth that is unsigned. And so anyway, we're here for an initial hearing and to make sure that you understand your charges. What is your date of birth?
I do not understand. I am here on a special appearance of Bo Thomas Maitland in all caps letters on a special appearance of the case number of 46D04-2602-CM-0250.
Correct, but I need to tell you what you're charged with in this case. So first of all, how old are you?
I'm 29.
All right, what's your birthday?
You guys should already know that, correct, or no?
No, I don't. I don't know what your
I don't
birthday is.
understand. I don't understand.
I just need you to tell me,
Here's the
court.
problem. If we don't know who you are, there'll be a warrant issued for your arrest. So we're trying to get past that level.
Okay.
Okay, so state,
Then you didn't get these papers. I'm gonna give them to you.
okay, so let's back up. My job is to make sure you understand what you're charged with. I have what you filed, and that's made a matter of record. What is your date of birth? Well, you know what? Let me see here.
I'm.
Okay, hold on. I do have it. Is your birth date 9/6 and you're 29 years old? Is that correct?
That is my living man. Yes, that's when I was born, but not this all caps name that's on the docket that you sent me papers for.
Okay, yeah, so
Special
your
appearance.
correct name is, I had that right here too. Well, you signed it, Bo Matlin, what you entered into the court.
Yeah, but not in all caps.
Okay, all right, that's noted for the record. We have an address of 1 Michigan, and is that where you live?
I do not.
Okay, where do you
That's-
live?
That's me, my person, not this all caps name.
Okay, I understand that. We made a record of that, so that's not a problem.
Okay,
But what I need to know is if that's where you live in Galeen, 110 Eastern.
No,
That's not where you live?
that's where the physical man lives, not the all caps name.
That brings us to the conclusion of this hearing. The individual is scheduled to return to court in the coming months for another session, along with a jury trial. So there will likely be further developments as the case continues. We will keep track of how the situation progresses and share updates when those proceedings take place. For now, we turn our focus to a separate case in Indiana, where another individual is presenting similar arguments in court, providing a fresh example of how these types of legal strategies unfold in an actual courtroom setting.
Okay, the all caps name I've taken care of.
Okay.
Right, I understand your concern with that, taken care of, that's, well, that's noted for the record, that that's not the way your name is. But what I need to know is what your address, so that you can be properly notified of things that are going on in this court. So what is your address? Is that where,
Your Honor, the
you live?
Your Honor and the prosecutor have taken an oath of office, correct?
Okay, this is not your time to ask, so, okay, so we have to make sure that we go through the right procedure. You filed all that, so I understand where you're coming from, so to speak. But what I need to do, I have a job, and I would be not upholding my job and what I am sworn to do, if I did not inform you of these things. So I need to know if you live at 1 Michigan.
That
Okay.
the living man does, not.
Okay, the
not
living
all
man lives
caps.
there, correct?
Not the all caps, there's two different. it's-
Right, no, the living man lives there in Galeen, correct? At that address?
I don't understand.
All right, when you go home tonight, where are you gonna sleep?
In
Are you
my-
gonna sleep at this address, 1 in Galeen, Michigan?
That's where I reside, but that's not where
Right.
this corporation of my all caps name is.
Okay, so we've got that's where you live, so to speak. Then I also need to make sure that you understand your constitutional rights. So do you know what your constitutional rights are as a defendant in this court?
Yeah.
Everyone, the Constitution gives you certain rights that have to be followed, as a defendant here. So do you know what your constitutional rights are?
Yeah, I state on record, my constitutional law, section 39329 is Chicago Motor Coach versus Chicago, Lagar Chicago versus Chicago, Lagar versus Chicago, 29NE934.
Okay, that obviously is not a case that would be applicable here because this is Indiana, but I need to make sure that you understand that you have the right to an assistance of a lawyer if you want one. If you intend to hire one, you have to do within 10 days. And if any deadlines are missed or legal issues or defenses that could have been raised, could be waived or given up. If you're unable to afford a lawyer, the court will appoint one for you. You have the right to a speedy and public trial to the judge or a jury. And if you want a jury trial, there has to be a written demand with the court 10 or more days before the trial date. You have the right to require the state to prove the elements of the charge against you beyond a reasonable doubt at a trial in order to obtain a conviction against you. And throughout these proceedings, you are presumed to be innocent. You have the right to hear and cross-examine all witnesses appearing against you. You have the right to require witnesses to be present at any hearing or trial to testify on your behalf. And the court would assist you in that right by issuing subpoenas. You have the right to remain silent. You cannot be compelled to make any statement or testify against yourself at any hearing or trial. Anything you do say could be used against you. You have the right to be tried in the county in which this offense allegedly occurred. You have the right to appeal to a higher court if convicted. You have the right to demand the nature and cause of accusation against you and to have a copy of the information. If you plead guilty, you would give up those rights. Now, I'm not going to ask you if you agree with those things. I'm going to ask you if you understand what it is that I just read.
I do not understand.
Okay, what don't you understand? That was wrong.
Well, I mean, I just stated where I stand. and I
Understand,
don't
but
understand.
okay, those are your rights under the Constitution of the United States of America, as well as the Constitution of the state of Indiana. I am not going to ask you if you agree to them. I'm not going to ask you if you think they apply to you. I just want to make sure you understand those are your rights, if you choose to accept them or not. Those are your rights in this country, in this state. Do you understand that?
I do not understand.
The main point here is that a person's identity, including how their name is written or presented, does not change their legal status or where they are considered to live. No matter how someone chooses to format their name, official records and the law still recognize their connection to their place of residence. Personal preferences about naming do not override established legal definitions. In practical terms, an individual remains subject to the laws and jurisdiction of a location where they actually live and carry out their daily activities, regardless of how they choose to describe themselves.
We'll make for the record that you don't understand that, also that those rights have been read out in court, and so that you have been apprised of them. So state, could you tell the defendant what he's charged with and what the possible penalties are?
Your Honor, he is charged by way of information that alleges that on January 31, 2026, in LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally operated a motor vehicle upon a highway, a Ford Ranger with Michigan license plates D as in David, P as in Peter, T as in Tom, 9082, having never received a valid operator's license and not being exempt from those requirements under section 9-1-4-27. That is a Class C misdemeanor. A Class C misdemeanor is 60 days in the LaPorte County Jail and a $500 fine.
All right, so Mr. Maitland, again, I'm not going to ask you if you agree with that or if you think you're subject to that law, which of course we've established that you are, but you understand what the state is saying that you did that's against the law. Do you understand what that is that they're saying, that you hadn't ever received a license?
I mean, he stated a statute. That's not law. That's not constitutional law. You just asked me if I understand my constitutional law, and I do understand my constitutional law. And what he stated is a statute that doesn't apply.
Okay, so let me stop you there. So the statutes are pursuant to the Constitution. We can have no statute that violates the Constitution of the United States or the state of Indiana. So you can make your arguments on the law. All I need to know is if you understand what the prosecutor said.
I do not. I do not understand.
Okay, so what the prosecutor did, the prosecutor read to you what they have charged you with, the state of Indiana, what they charge you with, and what the penalty could be for you.
That's right.
So we're going to make a record that was read clearly out to you, and as the charge and the possible penalties, so that has been done on the record. I'm going to enter a preliminary plea of not guilty for you. And are you going to hire a lawyer, represent yourself, or ask for the public defender?
I'm going to represent myself.
Okay, all right, we'll make a record of that. I do need to tell you, however, you have the constitutional rights to represent yourself in this court. However, you will be going against the state, and they are attorneys who are licensed, who are very experienced, who understand the law backwards and forwards. I just need to make sure that you've heard me say that and that you understand that. But it is your right to represent yourself. So we'll make a record of that. And we're going to reset your case to, as given about.
I have a record to show that I don't understand the statutes that the state is putting upon me, and I don't understand where the constitutional law is coming from, because I'm stating the constitutional law, and you swore under an oath of office, and so did the prosecutor. So if you guys don't want to stand the oath of office, then we'll have to proceed from there.
Okay, all right, understood. Your next court date?
I just gave them one form vote to self-represent, just so you.
Okay, all right, so we got a form there, so you know what you need to do as a self-rep to represent yourself. And our next court date is?
March 25th at 12:45.
March 25th at 12:45.
Thank you.
That brings us to the end of this segment. The individual is scheduled for another hearing next week, and I will be traveling to Lisbon around the same time, so the next update will be shared shortly after I return. Based on what we have seen so far, this case is likely to remain interesting as it continues to develop. If you found this video useful, you can support the channel by leaving a like. And if it did not meet your expectations, your feedback is still welcome. Feel free to leave a comment and subscribe with notifications turned on so you do not miss future updates. Thanks for watching, and we will now move on to the next part.